All right. Welcome back. I hope everyone had a great weekend. So, I was all set to do a video from the channel Lone Wolf USUL. It's a compilation of a couple of minor traffic court matters, and which, you know, I'm probably still going to do for a later video, but as I was getting it loaded up, this one looked more fun. It's also from the channel Lone Wolf USUL. So, you know, go give him some love. I assume him. I don't know. It's AI voice. So for those of you who are new, I'm Joe. I'm an attorney licensed in the state of Utah. This video we're doing, I have not watched except for maybe the first 5 or 10 seconds just to check. It's titled Judge Mercer Faces an Expert Pro Se Defendant. And let's see, Lone Wolf's description. This pro se beat Bay County last year. He still went to prison, but he beat them. So this sounds promising. So I assume Bay County, I assume that's going to be Florida, but I could be wrong. So let's jump in.
From Sergeant Applewhite, Mr. Oliver wants just another court date like we did with Mr. Dunaway. Is that right, Mr. Oliver?
Yes, sir. I don't need a lawyer. Honestly, you can set it for trial. You can set.
So I thought your plan was to hire an attorney.
I am, but like you can really set it for a trial date.
Okay.
So I don't need a lawyer, but I'm planning to hire a lawyer. But don't even bother setting it for anything but a trial. Just set it right for trial. That's going to be a wasted court date. Because here's what's going to happen. If he does hire a lawyer, that lawyer is going to show up. Well, he probably won't even show up that day. He's going to put in a motion for a continuance when he makes his appearance because he's going to need time to get up to speed and actually prepare for the trial. And like I said, I haven't watched this yet. That was what we just watched was the full extent of what I've seen so far. But if he went to prison for something similar, is this a felony he's facing? So a lawyer isn't going to just, jump right in feet first into doing a felony trial without preparation. That's just asking for malpractice. So the other option is this guy doesn't hire a lawyer. So he shows up to the court date and says, you know what, Your Honor, I really need a lawyer. I need you to appoint one for me because I didn't manage to. Or, he could just represent himself, but we'll see.
If I give you a court date to hire an attorney, I don't mind doing that if that's what you want to do. So is your plan to hire an attorney or is your plan to represent yourself? Because if your plan is to represent yourself, it's a different process totally.
Either or, but you can.
No, it's not either or. Do you want to hire an attorney or do you want to represent yourself?
I represent myself.
Okay, then have a seat. I'll call you up in just a few minutes, okay?
All right.
And the judge is right there. It's not either or because it's exactly like I described. It's, the only way he's going to trial on the date stated at trial is if it's pro se. Because if he hires an attorney or wants, he could get the appointed attorney here and now, not at the trial. So the judge made the right choice. That's the only way to handle this.
You're good, ma'am. Thank you, Ms. Wiggins. All right, Mr. Oliver, come on up and try to figure your case out now that we got rid of those individuals that. All right, so Mr. Oliver's coming up. Mr. Oliver is here in case number.
I don't even know why really by law I'm here.
Okay, you're accused of violation of injunction for protection. And I'm going to open your file up and see what we can tell you, Mr. Oliver.
if he doesn't know why he's there, as a judge, Judge Mercer should be very concerned by that statement, because Judge Mercer says, you're here on allegations that you violated a protection order injunction. So if you don't know why you violated you don't know to stay the hell away from someone. So if you don't know why you're here, the judge has a surefire way to keep you away from the protected person, and that's to throw your ass in jail. And like I said, I'm pretty sure this is Florida. I think it's the Panhandle, because Judge Van is in Bay County, isn't he? I don't think I've done Judge Van on my channel at all, but he's a favorite over on Law Talk with Mike. I know Judge Van uses this Polycom server, same as Judge Mercer. So, Judge Van, they're not shy about putting you in jail there in Bay County.
Is there any way I can be provided with a copy of the affidavit?
Yes, sir. Yes, sir. In order to do that, you have to participate in the discovery process, which is the first thing an attorney would do if you're represented by an attorney.
Okay.
If you represent yourself, you've got to file certain paperwork saying that you want to participate in the discovery process.
Yes, sir.
But it obligates you to do certain things also.
File motions, etc.
It obligates you to provide a witness list.
All right.
So what the complaint says is someone named Rachel Tanner who received a call from her goddaughter, Ashante Moore, saying that Ashante, you had to, I guess there must be an injunction.
Can I stop before you go any further, sir, and waste your time? I don't have an injunction against me in Jackson County. So how did I violate an injunction?
Okay. Is there an injunction against you in Florida?
Yes, sir, it is.
Jesus Christ. Well, I don't have an injunction in that county, but other courts, they don't have to give full faith and credit to injunctions granted in other counties. And once again, this moron is self-snitching. Shut the fuck up. You've just admitted to the court. Yes, there is an injunction. Yes, I knew about it. I knew it's not out of this county. It's out of this other county. So that shows he has knowledge of it. That takes away a defense.
Doesn't matter if it's in Jackson County or not.
But I never had any contact with the person that the injunction was on, nor did I speak upon this person when anything occurred. Okay, by law, when you have an injunction against someone and it's third-party contact, it will be equivalent of me saying, hey, Judge Mercer, would you tell the person that has an injunction on me, this, that, and the third? If I see you and you're someone or have some type of relationship with this person, you just can't call the police on me and say, hey, he seen me and cussed me out, and you have an injunction on him, call the police.
But judging by what Judge Mercer said, we don't have the full story yet, but it sounds like it was third-party contact, even from what the defendant is describing as third-party contact. What do judges always say when they're granting the injunction, granting the protection order? You cannot talk to this person. You cannot have another party talk to this person on your behalf. You can't email them. You can't telegraph them. You can't send carrier pigeons to them. No contact means no contact. This moron sounds like he's describing third-party contact. That's a violation.
From what I read the affidavit off the internet. From what that's saying, I shouldn't even be standing right here right now.
Who is the injunction? Is it against Moore or is it against
I have an injunction
Tanner?
Against Rachel Tanner. She lives in Panama City, Bay County, Florida. The injunction is in Bay County. Basically, from what the affidavit is saying, me and her goddaughter got into it she called the person that the injunction is on to have them call the police on me and come down here. I never once said her name. She didn't say I said her name. She didn't say I mentioned my baby mother. She just said me and him got into an altercation. Call you and you call the police. That ain't legal. That shouldn't even be legal.
Ashante stated Kirk was driving the gray Nissan again. Kirk threatened Ashante, telling her he's going to kill her and her godmother. So she's saying that you did threaten Miss Tanner. And if that happened, that may or may not be a violation of injunction for protection. I agree that it's.
I'm not taking nothing for it. Like, I mean, no disrespect to you. I've been in front of you quite a few times. I'm not taking no deal. We can set it for trial. Ain't no in-betweens with me. We're going to go to trial. I'm not guilty of it.
Okay. So let's talk about who's going to represent you.
I represent myself.
Okay.
So that one does, at least from what we've heard, it doesn't sound yet, making death threats against a protected person, or at least saying, I'm going to kill that protected person. It's not good behavior. It's not a good practice, but it's from what we've heard, I'd argue, yeah, it's not a violation. Now, if he said to his daughter, you tell that bitch I'm going to kill her, and I'm going to kill both of you. And well, even though I'd still argue he probably didn't mean for her to communicate that. Is that the way he said it? Probably not. I'm just putting out a hypothetical, but it could be. So there could be a violation in there. That's the thing. That's why we have a trial. Or at least a preliminary examination. That's why we get the witness on the stand and let them describe it. That's why we don't just dismiss things willy-nilly when the defendant says, well, I never did that. That's what witnesses are for.
Mr. Oliver, you think that's a good idea?
I just, yes, sir.
When someone wants to represent themselves, I have to ask them under Florida law. I've got to go into their education, their background, their experience, why they think they're capable of representing themselves. You have an attorney that I've already qualified you for that he may get the case dismissed. And if he doesn't, you certainly at that point could say,
dismiss it. She can dismiss it.
Is the state's intent to go forward with the case at this point?
Yes, Your Honor.
What they've got right now, they're going forward with it.
Okay.
But Mr. McDaniel may be able to show them some documentation or some evidence to convince them otherwise. It happens fairly commonly. My suggestion is you take an attorney, and then if you decide to represent yourself at a later time, you haven't lost anything. On the other hand, if you're adamant about representing yourself, I've got to place you under oath and ask you those questions. You solemnly swear or affirm the testimony about to give in this case will be the truth, the whole truth, and nothing but truth, so help you God.
Yes, sir.
What's the extent of your education, Mr. Oliver?
Graduated high school in Malone, Florida.
Any college?
Some. I didn't finish.
Okay. Have you ever been through a trial before?
Yes, sir. I just went through trial November the 8th of 2022.
And it went through a complete trial?
Yes, sir.
And that trial, did you represent yourself or did you have an attorney?
I basically represented myself.
That doesn't answer my question.
Basically represented yourself? Well, yeah, I had an attorney, but he didn't do what I wanted. So, I went off script, and that's basically representing myself.
Basically, okay. So you had an attorney representing you. So you've seen the trial process.
Yes, sir.
And you're adamant that you want to represent yourself, which
Yes,
is your
sir.
constitutional right.
Yes, sir.
Here's what I have to tell you. This is what I tell people. What do you do for a living, Mr. Oliver?
I work at Port of Panama City.
Okay. Mr. Oliver, if I showed up at your job, what time you go to work tomorrow?
I'm supposed to be at work right now.
What time you go to work tomorrow?
6 o'clock.
If I showed up at 6 o'clock tomorrow to try to do your job, I would make an absolute mess of it. Why? I don't know what you do. I don't know how to do it. I don't have your skills. I don't have your training. I can't do it. What you're telling me is that you think because you've been through a trial that you know everything about picking a trial and that you can do just as good a job or better than an attorney who's been to law school for 3 years, college for 4 years, taken and passed the Florida bar. I have to discourage you from doing that.
Being honest with you, Judge Mercer, you probably don't even remember me for real.
I remember the name.
I just beat Bay County last November on this same type of stuff because my baby mama keep doing this.
The complaint says you went to prison.
I went to prison. I'm gonna be honest with you. I went to prison. Right here, you sentenced me for aggravated battery with a deadly weapon.
Involving the same people?
No. So
So it had
what's
nothing to
going
do
on
with it.
is a situation where these women keep calling the police on me, making allegations, and the police officers nor the state attorneys are doing their jobs correctly to identify this. It's several lies in this affidavit. You can pull up what I went to prison for right here.
But that's what the trial is for. That's what trial is for. Oftentimes, now I absolutely hate this policy. Like domestic violence is one of the worst things both for prosecutors and defense attorneys, because many states, I don't know if Florida is one of them, but many states have mandatory prosecution for domestic violence. So I'm not saying this prosecutor can or can't, but here in Utah, on these facts, prosecutors can't drop the case. So basically, even if if the spousal privilege exists, which it often does, you've got to be married for the spousal privilege to exist. But even if the spouse invokes spousal privilege, you're still playing chicken all the way up to the day of trial, because we're not taking a plea deal because you've got no evidence, but they're not dropping it because the legislature won't let them. So he's saying, well, the cops and the prosecutor, they're not doing their job. They're not investigating my innocence. Well, they have an accusation. They might not be able to drop it. The legislature in Tallahassee might have said, you must prosecute this. And I don't agree with that. Prosecutors need to be able to evaluate the cases they have. And who knows, this prosecutor very well may have already evaluated and said, you know what, I have an extremely strong case. This guy is a scumbag. He needs to go to prison again.
Here, I went to prison at this courtroom. I've never been to prison for violation of an injunction.
So when the complaint says that, that's not correct.
None of that is correct.
So let me ask this question. You've heard me encourage you to take an attorney, represent you,
Yes,
and
sir.
you still want to represent yourself.
Yes, sir.
All right. So having asked those questions, Mr. Oliver is certainly intelligent, and he's been through the court system. He's capable of representing himself and exercising his constitutional right to do so. Is the state ready for trial?
Yes, we are, Your Honor.
Okay. When are you ready to go to trial? We have a trial period this month. That is the 26th of September.
Yes, Your Honor.
You want to go ahead and get it over with, Mr.
September
Oliver?
26th, yes, sir, when we're doing jury selection, 25th
26th will be jury selection
and trial.
and trial.
Yes, sir.
So we're going to give you a notice for September 26th, Mr. Oliver. I would encourage you to consult with an attorney between now and then. If you change your mind, your attorney will file some paperwork saying that they're going to be involved. Otherwise, you need to be here
Honestly,
September
can I get
26th.
a little bit more time? Can I maybe have this trial date, maybe like around 40? I'm sorry, sweetie. But can I maybe like a 45-day period?
I'm sorry, sweetie. I realize this is the South, but you don't call the prosecutor sweetie. That's yikes.
So that's not even 30 days for me enough to pay. And I just found out about this last week.
We have September 26th, and then the next one after that is October 23rd.
That's good.
Ms. Bremer,
No objection, Your Honor.
October 23rd, jury selection. We're going to set it on a pretrial date for the case management date, just in case there's something that comes up, any issue regarding witnesses and so forth. And that would be October the, yes, October
Okay, so-
12th at 1:30. So
Me and her not, by standards of self-representation, me and her are not supposed to have communication without it being on record.
That's incorrect. That shows you that you do not know what you're doing. She can't have contact with you if you are represented. Even on the record, she's not supposed to be communicating with you. She communicates with your attorney. You are unrepresented. So in order to do discovery, you're going to have to email each other. I mean, I can't say for sure because this is Florida, but But, for me, if I want discovery, I'm going to put in a discovery motion to the court through the electronic filing system saying, sweetie, because that's what he called her, sweetie, I want all this. Give it to me now. But then I'm going to email her and say, sweetie, this is how you can give me that discovery that I asked for. And then she's going to either email me the discovery or she's going to email me, schnookums, the discovery you want is at the court clerk. You can go pick it up. I'm not going into court to go on the record to do discovery. That's ridiculous.
Okay, so what is the proper etiquette for me to communicate with her?
It's a great point that you just made, because what you said is not Florida law. I don't know where you heard that at. The Florida law does not prohibit you. What you've got to understand is what you say can be used against you.
Yes,
so
sir.
It's not a good idea to talk to the other side,
Yes, sir.
but you certainly can do that.
Okay.
There's nothing to prohibit that or stop that.
All right.
Because you're representing yourself.
Yes, sir.
If you're representing.
So what Judge Mercer was saying there, I'll paraphrase. There's nothing that says you can't communicate with her, but you should shut the fuck up, because anything you do say can and will be used against you and will never be used in your own defense. Because if you said it, you can't use it as a statement of a party opponent. She can.
Represented by an attorney, she can't talk to you without the attorney being present. But when you represent yourself, she can if she's willing to and chooses to. So,
and on top of that, anything your attorney says isn't going to be used against you. See how that works? Because that's not evidence. Now, it may be pointing in the direction of evidence. It may be pointing things, it might be inadvertently waiving privilege, but it's not evidence. It's not testimony, or at least it better not be. The attorney has royally screwed up if it does become evidence.
I would again encourage you to seek an attorney, but if you decide to represent yourself, these will be your court dates, and those court dates one more time, and then I'll see if you have any questions, are October at 1:30. So your next one's October 12th at 1:30. We're going to get you to sign it, Mr. Oliver. We're going to give you a copy of it once you sign it. Do you have any questions?
I got one question, this last one.
Okay.
Can you help me understand exactly how I violated, the charge itself doesn't stem from Jackson County. So how am I in Jackson County facing a violation of injunction?
If you have an injunction that's in Florida,
all counties can enforce it.
Yes. If the violation occurred. Now, what you're accused of, it's not a regular violation. You're accused of sending a message to her, and you supposedly sent the message in Jackson County. I'm not saying you did it. I'm not saying they can prove it. I'm telling you that's what you're accused of.
Yes, sir.
Okay?
Yes, sir.
We'll see you on that day.
Yes, sir. Thank you.
And that's another good example of he doesn't know what the hell he's doing. The judge should have emphasized that. You don't understand what you're charged with. You don't understand how they can charge you with it. But they can, and they did. And your attorney, if you choose to accept one, would be able to explain that to you. I, as the judge, can't explain that to you because I am not your attorney. I do not represent you. I can tell someone to do that. I can't do it myself. So I didn't realize that this was all the way back in late August, early September. Well, there it is, August 28th. Silly me not looking at dates. It was the second video when I Googled Lone Wolf. So, looking to the comments, unfortunately, I can't tell you how the trial went. Sorry. But, so, that's the end of that. But, in order to not get people yelling at me, you talk too much. I saved this for the end. So I've mentioned many times that, you know, in addition to being a lawyer, I did my bachelor's and master's degrees in finance, and, you know, my channel is technically branded as a finance channel, but I haven't done anything finance yet. I still have every intention of doing a considerable amount of financial content. I'm still going to do sovereign citizens, legal discussions, lawsuits, stuff. And, you know, I realize it might be a mistake doing both on the same channel. That's what they say. But I figured there's so much overlap between law and business and finance and all that, that it would be difficult for me to separate out some things. But so, point is, I'm going to start doing finance stuff. And fairly soon, maybe not as my first video on finance, I'm going to discuss what I did for my master's dissertation. I need to finish reviewing it first, but it's interesting, I think, value investing. But I'm also, I think, kind of as a regular feature, that I want to do sort of, I don't know how to describe it, but sort of do analysis of subscribers' financial conditions. So sort of have people send in, you know, income, age, expenses, you know, rent, the or mortgage, whatever, what their retirement looks like, what, you know, here are my investments, here's what my mortgage is, and sort, you know, think sort of Susie Orman or you know, Dave Ramsey, but without the right-wing Christian aspects of his financial planning analysis stuff. So I haven't put together sort of the package that how I want to do that yet, but I'm thinking I want to make that a fairly regular feature, you know, once a week, twice a week, whatever. So, you know, if you're, you know, if you've stuck around this long and you're interested in, you know, volunteering as tribute, basically as one of the first contestants, you know, send me an email, leave me a comment, whatever. It's going to take me a little bit to get everything together, and I'll respond by emailing sort of the package to put it together. And I haven't decided yet if I want to do it, you know, as live streams, recorded videos, what. It's still new. So either way, if you're interested in participating, let me know. And so, yeah, other than that, thanks for joining me tonight. Hope you enjoyed this one. If you did, like, share, subscribe, do all the fun YouTube-y things. And I will see you very soon for the next one. Bye-bye.